Okay, good morning to everybody. Thank you for joining us this morning. So we are here to talk to you about business reorganisations and redundancies. We are recording the session this morning. That really is just for our own marketing purposes. So if anybody does want to be asking any questions towards the end of the session, please don't be shy and do chip in. We can turn the recording off and we won't share any recordings externally. So we're really pleased to be here this morning. I'm going to start sharing my screen with everybody. So hopefully there's a PowerPoint slide appearing on your screen now. Can I just get Rich or Rebecca to confirm that you can see that?
Yeah.
Fabulous. And I will just hopefully give panel controls to Rich and Rebecca as well for the purposes of the presentation this morning. So first of all, welcome. Hope everybody is getting ready for Christmas. It's not too far away now. Get this. Okay, there we go. So as I said, we're going to talk about managing redundancies. I'm sure it's going to be a really topical subject over certainly the next few months into 2023. We've already seen probably too much in the news already, with various companies either going into administration or wide-scale redundancies that we've seen reported in the press. I'm here this morning. I'm Lauren Harkin. I'm a partner in the RWK Goodman employment team. I'm joined by my colleagues Richard White and Rebecca McCollum, and we're going to talk to you about the various sort of key aspects of the redundancy process this morning. Before we start, we do have an RWK Goodman Employment Law and HR group on LinkedIn. Please do tell us what you think of the seminar. So please post any comments where we've kind of given the seminar a bit of a boost on the LinkedIn group. Please tell us what you think. If you're not a member of the LinkedIn group, please do request to join. You'll see lots of interesting blogs, sort of HR topical, employment law related articles on there. So without wasting too much time, I'm going to launch right in and start with the definition of redundancy. So if your organisation is carrying out a redundancy exercise, the sort of starting point, I would say, for all HR specialists is to revisit the section 139 of the Employment Rights Act, the definition of redundancy. So what that piece of legislation basically says is you will have a redundancy situation where there is some kind of reduction, reallocation or relocation of work. So the wording's on your screen there. So either the employer ceases to carry out the business, or they change the place of work, or the one that fits most sort of people's definitions when you're not closing a business or you're not moving a business is that work of a particular kind ceases or diminishes. The key thing here is it's about there being either less work or different work. It doesn't necessarily always have to be about reducing costs, and you'll hear us talk about sort of where people are changing workplace and things like that. So the next slide is just to sort of talk you through why this sort of term redundancy is important. So first and foremost, you need to get it right. If it's a redundancy dismissal, any employees that are made redundant are entitled to receive statutory redundancy pay. So that's why the term redundancy is important. But also redundancy is one of the potentially fair reasons for redundancy. So if you do have any employees that wanted to challenge a redundancy dismissal as being unfair, then actually you can say, well, no, redundancy is a fair reason to dismiss, providing obviously you carry out a fair process and it meets that statutory definition that I dealt with on the first slide. The other thing for employees, of course, as well, is that if an employee is made redundant, they may have their own mortgage protection or insurance benefits or something like that. So there could be a benefit there, so you need to get it right. And also collective consultation requirements if you're making 20 or more redundancies. So just make sure if it's a redundancy dismissal, you are getting it right. Who's covered? So it is limited to employees. I'm sure if you've heard us talk before, we do talk about other categories of workers, so contractors, workers, employees. It is only employees that's covered by redundancy or redundancy rights, although it is important to consider the treatment of other categories of workers, such as contractors, when you consider the overall fairness of your redundancy exercise. So, just sort of at the outset of any process, what are you doing with contractors? Those sorts of questions before you actually embark on your redundancy exercise. Reorganisations and a reduction in work. So sometimes sort of the obvious point about a reduction in work is not always obvious. And obviously in the sort of world we live in today, restructures and redundancies are often triggered as a result of computerization, automation, changes just in the way services are provided generally, or the way services are supplied. So it's not obvious sort of downturn necessarily. It might be about doing things differently as well that can trigger redundancies and reorganisations. The other point to say is that sometimes outsourcing arrangements, so if you're an organisation that might outsource various aspects of your work, that can obviously trigger redundancies, but it's important for us just to flag at the outset that the piece of legislation we all refer to as 2P, so the Transfer of Undertakings Protection of Employment Regulations, falls into outsourcing arrangements, or certainly to most outsourcing arrangements that are caught, and that will make that any dismissals that are in connection with a 2P transfer, they're automatically unfair unless you've got an economic, technical or organisational reason to justify it. So the key point there is if it's an outsourcing arrangement, then you might have 2P requirements that could very well require obligations to inform and consult with staff on 2P, as well as potentially collective redundancy consultation. So just be very, very careful there if you have one that covers both transfers and redundancy. You will have seen on the first slide that we spoke about this work of a particular kind diminishing or ceasing to apply. And whilst the legislation talks about work of a particular kind, there isn't any actual statutory definition for what work of a particular kind means. But what we've seen with the redundancy cases over the years is it is about the reality of the situation. So the courts will look at, what an individual does. It's not necessarily just about job title, it's about what individuals are doing to make a determination whether that work of that kind is actually going to diminish or come to an end. I mentioned at the start that it can include changes in location. So just sort of be mindful that a redundancy exercise can be triggered where you've got a site move. So an employer is going to move from one site to another. That can trigger a redundancy exercise. And obviously, if you're a large organisation with 20 or more people, then that will trigger your redundancy collective consultation as well. So just be really mindful of that. It is an easy thing to just suddenly think, well, actually, if we are moving, if we are relocating, we'll just rely on a mobility clause that's in our employees' contracts. And while this may be possible in some circumstances, particularly if you're moving a very, very short distance or within a reasonable travelling distance, mobility clauses are not always the complete answer. It's not always going to give you that way to avoid making redundancies. One thing I would always say is if you do have mobility clauses in your contract, you do need to decide at the start of the exercise, is this a situation where we're going to rely on mobility clauses, or is this actually where we have to run a redundancy exercise? Because once you take one route, you can't change to another. And we've seen sort of plenty of cases over the years where you have either very widely drafted mobility clauses that perhaps lack certainty, that don't work, or they're not relied on reasonably. So it's not okay to simply say, well, actually, we've got a mobility clause in our contract. We don't have to do a redundancy exercise here. You have to look at the reasonableness of that mobility clause in relation to the employee's effects. So, for example, somebody that has to go from a 20-minute commute to a 2-hour commute is not necessarily going to get it over the line as being reasonable. So do just sort of be very mindful when you're dealing with location changes to find out whether it is a redundancy exercise or indeed it's something you could rely on a mobility clause. I'm not going to spend very much time on maternity and sick leave because it really is a topic in its own right. But just to say, if you are carrying out any potential redundancy or restructuring exercises, be very mindful of those people that are on any form of leave. Because often that redundancy situations arise as a result of the sickness absence. And that can make it itself automatically unfair. There's also special treatment afforded to those that are on maternity leave in terms of suitable alternative roles that I know Richard's going to pick up on later. So moving on to fair procedure. The first thing to say is if you are carrying out a redundancy exercise where you plan to make 20 or more redundancies within a 90-day period, you do have an obligation, a legal obligation to notify the Secretary of State that you're going to do those redundancies. It's a criminal matter now not to make that notification. It's a criminal offence. So you must do it. It's a very straightforward form. It's called an HR1 form. And as I've said, failure to do so is criminal offence, but also it gives rise to claims for protective awards where you don't do it. And those protective awards can be up to 13 weeks pay per employees. So really, really important. And the HR1 form is nothing to be sort of alarmed by. It's literally a 2-page form that you can complete online. With your notification requirements, this also triggers collective consultation. Where you're doing this 20 or more redundancies. And whilst Richard's going to talk about it in a bit more detail about collective consultation, the one thing I just wanted to note here is the wider definition of redundancy for notification requirements. So on my first slide today, I put that sort of legal definition of redundancy up there. But in terms of notification requirements, it's not just those sort of planned redundancies under your redundancy exercise that will trigger your notification to the Secretary of State. You also have to move into that things like some other substantial reason dismissals, voluntary redundancies, so perhaps people if you use settlement agreements, they all come within that definition. So it's always a bit of an analysis to say, well, actually, you might be planning some redundancies in the next 90-day period, but are there other people that potentially come into that mix for the notification? Who do you need to consult with? Is a question we often get asked. Two aspects of that. There's going to be collective consultation, and collective consultation is either with a recognised trade union or directly appointed representatives, or you may already have a body elected for your representatives. And then the second aspect is individual. So you will need to individually consult with those people that are identified at risk of redundancy after a scoring exercise or something, as well as any collective redundancy requirements. Next on my slide, I just thought it would be worthwhile just sort of flagging the difference between sort of reorganisations and redundancies, or what we might call selecting in versus selecting out. Most sort of redundancy exercises that we advise on involves a sort of what we call a selecting out type exercise. So it might be that you have a number of people within a team. So let's just say you have PAs within a team and you need to reduce the number of PAs from 4 down to 2. Or you have a number of specific operatives and you're going to reduce the number from 10 down to 7. What tends to happen there is that we look at selection pools, so you get people together that do similar work, and then criteria, and you select out of that equation. However, within other reorganisations, particularly when businesses need a different type of a skill set, you have this sort of selecting in type idea. So as an example, my PA example before, instead of going from 4 PAs down to 2 PAs, the plan for the business is actually we're not going to have any PAs at all. In fact, we're going to reorganize the business. We're going to create a new role that's called an executive assistant, and the existing PAs are invited to apply for the new roles. Now, it might be within some reorganisations that there's enough roles for everybody. It's still a redundancy exercise, even if you don't actually anticipate having to make any redundancies. So in those types of situations, normally what you have is you have the new roles advertised, and you invite the staff to apply for the new roles. And you would probably have some kind of competency-based interview or an assessment centre or something like that. You do really have to apply your minds to these situations where you're going to basically select people into roles as opposed to selecting them out, because what are you going to do with people who you may want to retain their skill set, but they decide they don't want to apply for any roles? So it's something really to give some thought about what you're hoping to achieve within your redundancy exercise. And whilst the sort of next part of what I'm going to talk about really does deal with selecting people out, where you're keeping the various different roles that you have within your organisation, you're just reducing the number of people, doing a selecting in type redundancy exercise often does happen, particularly when we've got this automation, computerization type, of situations, because actually what you need to do is you just need people in different roles to utilize the skills that they have. Before I move on to my next slide, I'm just going to say a little bit about why actually selecting people in can give you greater flexibility. And the reason there is when we talk about selection criteria, so that's when you are selecting people out, that selection criteria does need to be fair and objective when you're choosing to make people redundant. However, when you're selecting people in, you can have a redundancy process, and as long as that sort of interview process is within a band of reasonable responses and it's not discriminatory, actually what people do at interview is make views based on their own subjective opinions. So you can get a bit more flexibility as such with that approach, but you do need to give it some thought. Key things in terms of procedure generally with redundancies is to establish your selection pools, do your criteria, and then consult. So they're the kind of critical aspects. It's worthwhile, before I just jump onto the next slide, just mentioning volunteers. So people actually do ask us quite frequently, if I'm doing a redundancy exercise, is it necessary for us to ask for volunteers to put themselves forward? The answer to that is no, it's not a legal requirement, but it is something you certainly should apply your minds to before you start any redundancy exercise. So pools for selection. So the first thing to say is, generally speaking, if your decision to make somebody redundant was challenged by an employee and it went to a sort of an unfair dismissal hearing, tribunals do give you quite a wide degree of discretion in terms of determining what your appropriate pools for selection are. And so provided, again, you apply your mind and the people within the pools is reasonable. So they're doing what we normally call similar work or interchangeability of work. So don't just look at job titles is always my advice. So if you're determining a selection pool, you need to look at what work do you have, what work is ceasing or diminishing, who is doing similar work, or who's doing work that's interchangeable. So they might be doing similar work, but equally you might have people that are doing interchangeable work. So although one role they have is sort of their normal day job, they can do work that's interchangeable with another. The other thing to say is with calls for selection, if you are a business that recognises a trade union, we would always recommend, and indeed your collective agreements might dictate that you have to do this, but we'd always recommend that you discuss the choice of pool for redundancy with the union before you start putting people into the selection pools and applying scoring. So that's one thing absolutely you should do if you recognise a union. Also be mindful of multiple sites. So if you're a business that has multiple sites and you're having redundancy selection pools, just sort of have a think about geographically how close together are your sites, and also what is the degree of movement of employees between sites, because it may not necessarily be fair if you have sites in, say, Swindon and Chippenham, or Chippenham and Bath. If employees genuinely move between those sites, you might not just want to have location-specific pools. It may be that with your business that is appropriate, but just sort of apply your mind to those questions before you go ahead with your pools of selection. Another question that we often get asked, and we are having to do a very sort of quick whistle-stop tour this morning of the sort of key elements of a redundancy exercise, but one question we do often get asked about is something that's called bumping. And this is basically a situation where somebody that's more senior is placed at risk of redundancy, and they can run an argument to say, well, you could bump a more junior employee out of their role in order to make room for them if they want to sort of retain a specific skill set. There is never a legal requirement to bump people out of roles, so never a legal requirement to bump more junior staff out of a role for a more senior person. However, it is relevant to at least consider whether this might be appropriate. Obviously, the key points are, how different would the remuneration be? What are the relative length of service? Qualifications. Is there a specific skill set that you need to retain here if you are going to consider bumping? And then finally, I've put at the bottom of this slide here, pools of one, which often you now refer to as sort of unique job redundancies. So when you're carrying out a redundancy exercise, it tends to be the case that either you've got a pool of people, lots of people that do the same or similar work, or you have a unique job redundancy. And that is obviously fine as well, provided you can justify that it's a specific role, there's only one person in that role, that you no longer need to have the requirement for that role. The only thing to say is with the pool of one or with the unique job redundancy, tribunals are likely to sort of scrutinise that decision a little bit more, because obviously it's just that one person that's affected. Before I jump onto my final thing, I just wanted to mention fixed term employees. So they generally should form part of any redundancy selection pools. Fixed term employees are protected against less favourable treatment. So don't just think you can just let sort of fixed term contracts come to an end. Do apply your mind to the whole fair process. The last part from me for this morning is just about choosing and applying selection criteria. Key thing is it needs to be objective. Your criteria needs to be what we would call capable of independent verification, clear and transparent, and non-discriminatory. So when we talk about what criteria are we going to use to score individuals to make a selection for redundancy, the sort of commonly used ones you tend to see is disciplinary records, performance, so things that you can back up with your data from appraisals or annual reviews, skills and experience and knowledge, all those things that again that are objective, that you can independently verify, from the reports that managers have prepared. Absence records, although obviously with absences you do need to disregard disability or pregnancy related absences. You can use things like aptitude, although it's more difficult to assess sort of objectively. You've probably heard of last in, first out. Historically, it was very common in redundancy exercise, much less common now, because it can amount to indirect age discrimination, with younger employees having typically less service. With any redundancy selection exercise, you always have to sort of ensure that specific employees are not disadvantaged by the criteria. We've mentioned already pregnant employees, those on maternity, those on sick leave. And what we saw many years ago was a case, and it was a law firm actually, that had a lady that was on maternity leave and a gentleman. They were both solicitors, and they used a criteria that was lockup to basically score them. But where they kind of fell down was because the female was off on maternity, she didn't have up-to-date figures for her lockup. And what this company did was they went too far and said, well, actually, we'll give her maximum points. And what that did was actually unfairly disadvantaged her male colleague who successfully brought a sex discrimination claim. So don't go too far and sort of artificially inflating scores, but look at the whole exercise. And actually what the court said here was actually if you'd have applied a different time period for the scores, you could have done it fairly. So basically with sort of fair selection criteria, my advice always would be consult with employees at risk of redundancy about your pools and your selection criteria before you do your scoring. And the reason for that simply is that there's no surprises. If you tell people who they're going to be in a pool with and you tell them what they're going to be scored on before you do the scoring, it gives them much less to complain about. Whereas when you've done the scoring, they're going to complain about the scores as well as the criteria. So that's the first bit of advice I would say. Second of all, make sure you've got independent manager or managers to conduct the scoring that are appropriate. So, you know, if you've got a big team of people, that might be appropriate to have a couple of managers, but to have a moderation exercise for scoring to again ensure fairness. Again, you know, let them see the criteria, as I've said, before you do the actual scoring. Give employees that do score the lowest opportunities to challenge their scores. And then ultimately, when you go through that exercise, there will be an opportunity to appeal. So that's everything from me in terms of criteria. I can see that somebody's got their hand raised. So does anybody need to ask any questions at this point? Or can I move on to Rich and perhaps we could deal with questions at the end? I think we'll move on, Rich, and then perhaps pick up questions either in the chat box or at the end.
Thanks, Lauren. I think we have got some questions in the Q&A box at the moment, so we'll certainly try and pick up as many questions as we can, won't we, at the end. Lauren, I don't seem to have the arrows to enable me to move the slide, so if you could do that, that would be great. Thank you. Morning, everyone. As Lauren said earlier, my name's Richard White, and I hope all of you are a bit warmer than I am this morning, because I am freezing cold in our office. And these aren't actually headphones, they're earmuffs. So it's just purely there to help keep my ears warm. So I'm going to talk, Lauren's talked generally about the overall need to follow a fair process and gone into a bit of detail about selection. I'm just going to talk in a little bit more depth about consultation and what are the requirements in terms of individual consultation and collective consultation. And then I'll spend a little bit of time just on alternative employment that you need to consider. So going to talk a little bit about individual consultation first of all. So in other words, what I'm talking about here is principally a process where you are not making large scale redundancies. So less than 20 proposed redundancies, where you would have to just effectively individually consult with staff. But individual consultation does also come into a collective consultation process, because once you've done the collective bit, you will need to individually consult as well. So this is relevant to both parts that I'm going to talk about in terms of consultation. So there was a case, any of you who've been in tribunal before will probably have heard of a case called Polkey and Dayton Services, which is a kind of really important case in redundancy and other cases as well. But one thing that case said was, if you want to show you've acted reasonably, you have to warn and consult your employees about proposed redundancies. So if you don't do that, then you're probably starting from a fairly sticky wicket. So some examples of where employers have not consulted at all or very much. And what's happened in those sorts of cases? Well, largely, if you try and argue that, well, we didn't consult, but we had a good reason not to consult, you know, we didn't really need to, it wouldn't have made any difference. Generally speaking, that's not going to put you in a very good position, and probably that will mean any dismissals would be unfair. The size and administrative resources of the organisation is always relevant to whether or not you've acted reasonably, but it's not an excuse to shortcut consultation. So small employers, medium employers, large employers, you all have to warn and consult your employees about potential redundancies. And even an employee who doesn't really want to be involved in consultation, be wary of employees who, this does happen from time to time, who say, oh, well, this is, you've made your mind up in advance, I don't really want to bother coming to any consultation meetings. You can't force someone to come along, but you need to still show that you've made reasonable efforts to consult with someone who might not want to engage in that process, just so you can show you've discharged your obligation to go through a consultation process. So broadly speaking, the key components of a fair consultation process is that you start the process when you still have proposals in mind, rather than we've decided exactly what we're going to do, and now we're going to talk to employees about what that means for them. Ideally, if you're talking about changing the structure of a team or a department, for example, you want to talk to employees when, you know, you're still proposing to do that, and you give them an opportunity to feedback with any alternative proposals, for example. You need to give your employees adequate information in order to respond to whatever it is you're proposing. They can't really put forward alternative suggestions or think about ways to avoid redundancy unless they have some clear, good information about what it is you're proposing to do and why. So you need to be really clear on that. You need to give adequate time to respond. So, you know, if you put someone at risk on a Monday and have a consultation on Tuesday and then dismiss them on Wednesday, then, you know, that's generally speaking not going to put you in a particularly good position. So you do need to give people time to reflect and come back to you with their own proposals or their thoughts. You know, consultation doesn't just necessarily mean one meeting. You know, it might do if it's relatively straightforward, but consultation is generally a process. So you have to allow that process the time to be dealt with properly. And you have to show a tribunal, if need be, that you have conscientiously considered what the employee may have said to you during that process. So those are sort of the broad aspects of individual consultation. A little bit, just getting a little bit more specific. You would want to set out in any sort of at-risk communication, and when you talk to your employees about the fact they are going to be put at risk, you'd want to clearly lay out the business reasons for the proposals. So not that we're proposing to reduce from X to Y, but why is it we are proposing to reduce the number of employees from X to Y? Ultimately, it's always going to be your decision as an employer as to whether or not you retain people and whether or not you decide to go ahead with what you've proposed. But you do really need to set out the business case and allow employees then the opportunity to respond. Lauren talked earlier about how you decide on who's going to be put at risk of redundancy. So who's going to be in the pool of people that that are being consulted on about redundancy. You'd want to set out, with enough detail so that people can understand why they are in that pool of people who are at risk. So that again, they may want to challenge that or put forward alternative proposals. Lauren already alluded as well to setting out your proposed selection criteria. Really good practice to do that. If you don't do that, it doesn't automatically mean that it's an unfair process, but it's very helpful to narrow down the issues that might be argued later on if you've told employees what you're proposing to do in terms of criteria to select for redundancy. And then I'll get onto it in a little bit more detail in a few minutes, but you obviously suitable alternative employment, so avoiding redundancies by redeploying staff is obviously a really key area in terms of consultation, and also mitigation of any dismissals. So mitigating the effect of someone being made redundant. So are you going to enhance redundancy pay at all? Are you going to offer any sort of support or outplacement to people who are at risk or maybe made redundant? So that's really, it's important not to forget those things and focus purely just on the redundancy reason itself. So, one thing I would echo in terms of what Lauren said earlier is, and I've seen that, I probably say this because I've seen a few cases recently where the employer hasn't given feedback to the employees who've been selected in terms of their scores. So I've seen that in a couple of cases recently where the employers plowed on ahead, told the employee that they've been selected, and then started to consult about suitable alternative vacancies. You do need to give them the opportunity, as Lauren said, to challenge or understand the basis on which they've been selected. If you fail to do that, that's probably in itself enough in a lot of cases to render the whole process unfair. So that's a really, really important point. It doesn't mean you have to give them details of everybody else's scores, but it does mean that you would normally give them their scores and the opportunity to challenge it, because sometimes you may have made a mistake. The data that has been used may be wrong. So it's really important to give them that opportunity. So that was a little bit on individual consultation. Lauren, if you could just move on to the next slide. Thanks. So collective consultation. So this is a statutory process. So individual consultation that I've just talked about basically just comes from case law, where tribunals over the years have decided what is fair and what isn't. Whereas collective consultation is a statutory animal. Therefore, you have to follow these processes laid down in statute. Otherwise, if you don't follow the collective consultation requirements, there is a financial penalty that is imposed by a tribunal. To give you an example of how that works, so let's say you had 50 employees who were affected by a redundancy proposal, and you didn't collectively consult with them properly or at all. Then a tribunal is entitled to make an award of up to 90 days gross pay per person, per affected employee. So if the average 90 days gross pay for each employee was, let's say, for argument's sake, £8,000, multiply that by 50, that's £400,000 because you haven't collectively consulted properly. Now, also bear in mind that the tribunals don't say, oh, okay, we'll start from zero and then we'll see how far up we go towards that 90 days. They start at 90 days and they have to be persuaded to award less than 90 days compensation. So quite a penal sanction. That's why it's important to get it right as far as you reasonably can. So the definition of collective consultation and when it applies is where there is a proposal to dismiss as redundant 20 or more employees at one establishment within a 90-day period. So there's quite a few different bits to that definition. As Lauren said earlier, just be wary from a collective consultation point of view. Redundancies, where you propose to dismiss as redundant 20 or more employees, that's actually a broader definition than pure redundancy. So it applies when you are looking to change people's terms and conditions of employment, for example, on a large scale, not just to redundancies. So be really, really careful of that. So that's one issue, redundancy. Second question is, do you 20 or more employees? Well, employees, it does only relate to people that you directly employ as a company, not, for example, agency staff. Also, for the purposes of deciding whether or not you are proposing 20 or more dismissals within a 90-day period, fixed term employees, if you are going to let their contracts naturally finish at the date that they were going to finish anyway, strictly speaking, they don't form part of the 20 when you are looking at whether or not you are needing to collectively consult. That said, as Lauren said, don't just say, oh, well, fixed term employees are over here then, we don't need to worry about them. They don't count towards the 20 if the contracts are going to end as they would have done anyway, but you still need to pick them up as part of the consultation process generally, because assuming they may still be affected by the proposals to some extent, they still need to be included. Similarly, if you're going to end people's fixed term contracts early because of the proposal that you're making, they definitely need to be included and they would form part of the 20 or more employees. The definition on the screen there talks about at one establishment. Well, there's lots of case law on that. So if, for example, you're looking to make 15 employees redundant at a site in Bristol and 15 employees redundant at a site in Newcastle, it may well be the case that they are two separate things, and you don't have to collectively consult, even if it's the same company that's making those 30 redundancies, because it may well be that you can treat those two things as separate establishments and you don't have to amalgamate the 15 and the 15. That said, it's just something you absolutely have to be careful of. You want to be satisfied that if you aren't going to collectively consult, that you are comfortable that you're not making 20 or more redundancies at any one particular establishment. It's often geography based, but that's not the only question, so you have to be really careful with that. It's within a 90-day period that you have to focus on, so you're always looking over a rolling 90 days. So just be a little bit careful if you think, oh well, we know we need to make 30 redundancies or 100 redundancies, but what we're going to do is we're going to make 10 now, and then we're going to make 15 now. We're going to make 15 in just over 90 days time. That might be okay to stagger the dismissals in that way, but that can put you in a tricky situation sometimes to show that whether or not you've consulted in good time in relation to all of those dismissals. So just be a bit careful about the 90-day period. You have to think about that. Sometimes you have to be, tribunals can expect you to be a little bit clairvoyant, in terms of you make 10 redundancies now, and then in 2 months' time, you need to make another sort of 10 or 15. Potentially, you might still need to collectively consult over the second batch. So just be aware of that. So, one other thing as well, I've talked about employees. What about the employer? So it's each 20 or more redundancies when you're looking at the number of dismissals. You only apply that to each individual company. So if you've got a group of companies and one employer within that group proposes 18 redundancies and another employer within that group proposes 18 redundancies, that is not going to trigger collective consultation because it's only individual employers who are where you're looking at the numbers that are relevant. Who do you need to consult with? I'm not going to spend ages on that. Either you would have to consult with a recognised union, assuming that they represent the employees or the group of employees that are affected. Alternatively, unless there's a standing body of employees who are already elected to consult on these type of issues, which is fairly unusual, then probably you would have to go through a process of inviting people to stand as elected representatives, and you may need then to follow an election process to decide who is going to be an elected representative. There's specific rules that apply on elections, which you do need to follow quite closely. I'm not going to bore you with them now because they are quite dull, but you do need to get them right. One of the key questions is how many representatives are you going to need? And you have to address your mind to that because you have to act reasonably in terms of the number of reps that you're going to require. Okay, so has consultation begun in good time? That's usually quite an important question. So in essence, you want to start as soon as you sort of develop a pretty firm proposal that, and you know that redundancies are likely to be required, you'd want to try and start consultation as soon as you reasonably can once that proposal is fairly clear. That doesn't automatically mean that you would fall foul of the legislation if you don't start consultation pretty soon, but generally that's what you would want to try and do. Be really careful of the 30 days and 45 days minimum consultation periods. So 30 days for 20 or more dismissals, 45 days for 100 or more dismissals, that's the minimum. You have to try and consult with the representatives with a view to trying to reach agreement over the proposals. So if you rush the process, get it done in 30 days because that's what we need to do, but you haven't really meaningfully consulted, you haven't really tried to reach agreement with the union or with the reps, you probably still haven't collectively consulted properly. So those are minimum periods, not the period that you have to follow. That will always apply. One other point to bear in mind is that 30 days or 45-day minimum periods, they apply not from the date that you tell employees that you are proposing redundancies. That period of time starts from the date on which you give certain information to the elected representatives or to the union. So bear in mind, it's going to take you a bit of time to elect reps if you don't have a recognised union. It's only once you've elected the reps that you can then give them the information. the consultation period starts from that point on. It's called Section 188 information because that's the section that it's in the legislation. It only starts running then, not from the date on which you sort of told everybody about possible redundancies in the first place. So be really, really careful about that. That's what I was going to say on collective consultation. It's a really big area, but I just wanted to highlight a few of the key points to consider. Lauren, if we could just move on to the last slide. Okay, so let's assume you've collectively consulted, and then after collective consultation with the reps, you've had to go through a period of individual consultation with the employees who remain at risk of redundancy. As I said at the beginning, one area obviously to focus on is the search for alternative employment. And you'll all no doubt have heard of the reference to suitable alternative employment. You know, is there a suitable alternative vacancy that I can offer a potentially redundant employee? So it's really important. One, because you have to do it anyway as part of a fair process. Two, it may be relevant if you offer what you believe to be a suitable alternative role to someone and they refuse it. You might decide that you don't want to make them a statutory redundancy payment, but you can only do that if you've offered them a suitable role. And if they've unreasonably refused that offer, which we'll come on to in just a little bit of detail in a minute. So it's important for those two reasons. It's also important, as Lauren alluded to earlier, where you've got employees, for example, on maternity leave. If their role is redundant, and if you have a suitable alternative vacancy, which is suitable for that particular employee, then you are obliged to offer them that role in preference to anybody else, even though there may be other employees who might also be potentially suited to that role. You have to offer it to an employee on maternity leave who is at risk of redundancy first, before you offer it to anybody else. Now, bear in mind, that doesn't mean, so that it is confusing at times. If you've got, for example, 10 employees who are at risk of redundancy in a particular pool of labour, so 10 employees doing the same job, and you need to reduce that to 5 employees. So you consult, you select people, you select the 5 people that are going to be made redundant. At that point in time, the obligation to try and retain an employee on maternity leave doesn't apply, because all you're doing at the first instance is deciding who is at risk, who is going to be made redundant. Once you've done that selection process, and you are then looking for those 5 people who have been selected, you are looking for alternative employment for them. At that point, if any of those employees are on maternity leave, there is that statutory obligation to offer them a suitable alternative vacancy if you have one. If you don't have any vacancies, then clearly you can't offer them one. But if you do have any alternative vacancies that are suitable, you have to offer it to the employee on maternity leave at that time. Also, just a quick note, the government is consulting at the moment and considering extending the period of protection for employees. At the moment, it's only when they're on maternity leave. What the government's thinking of doing is extending it from the period of time from when the employee tells you they are pregnant until 6 months after they come back from maternity leave. That's the proposal. It's been proposed for years now, but it seems to be getting a bit more traction recently, so it may well come into force. I just want to say one final word on suitable alternative employment, which is it's a 2-stage test. So when you're looking at whether or not something is a suitable alternative role and whether someone was entitled to reject it or not, one question is the role itself suitable? So is it the right level of status? Is it on the same pay? Is it the same, benefits package? That's what's relevant really in terms of whether the role is suitable. The other question then is whether or not it's reasonable for the employee to reject that offer. And that tends to come down to things like the employee's personal circumstances. So even though the role might look suitable, if it's at a different site, for example, and that's going to involve more travel for that employee, it may be reasonable for them to refuse it. In which case, if they do refuse it on that basis, you'd still have to pay them their statutory redundancy pay. So always remember it's a 2-stage test. Right, I think I've said as much as I should say now because I've overrun a little bit, so I will hand over to Rebecca.
Perfect, thanks Rich. Hi everyone, so I'm Rebecca, and moving on nicely then from Rich's last point, which is statutory redundancy payments. So as Lauren's already identified, it's employees that are entitled to statutory redundancy payments, and not workers and not self-employed contractors. So just employees that are eligible. But they do need to have 2 years continuous employment. So any employee with less than 2 years employment is not entitled to a statutory redundancy payment. So in those circumstances, they would just receive, employees with less than 2 years, any unworked notice, so pay for any unworked notice, and then payment in lieu of accrued untaken holiday. But employees with more than 2 years service, they get the statutory redundancy payment. Rich has already covered off the point about a refusal of an offer of alternative employment. So in those circumstances where an employee has refused an offer of alternative employment, they lose their right to a statutory redundancy payment. And that can often be a bit of a dispute about that. An employee can bring a claim for payment of a statutory redundancy payment where they believe it wasn't suitable alternative employment. The employer is arguing that it was. So how do we calculate then a statutory redundancy payment? So it's calculated based on the employee's age, length of service, and gross weekly pay. So the employee gets half a week's pay for each full year worked where they are under the age of 22. They get 1 week's pay for each full year worked where they're aged between 22 and 40. And then they get 1.5 weeks pay for each full year worked where they're aged 41 and over. But there is a maximum of 20 years with a length of service. So if the employee has taken, if the employee is employed for more than 20 years, what's taken into account is just the 20 years. So for example, if you've got an employee that's employed for 25 years, you take into account the last 20 years and you discount the first 5 years. So there's a cap on the number of years service. Also, there is a cap on gross weekly pay. So the government sets the weekly pay every year in April. The current gross weekly pay is £571. So employees earning less than that, their full gross weekly pay will be used for the calculation. But employees earning more than the statutory cap, they won't get their full gross weekly pay. It'll be capped at the current cap. So the government does have a statutory redundancy calculator on their website, which is really useful. So you can use that to calculate the employee's statutory redundancy payment. I'm just going to go through an example for you, so a worked example. So where you've got an employee that's aged 52 and they've been employed for 15 years and they earn £600. So they're earning more, as that's their gross weekly pay of £600. They're earning more than the statutory cap. In those circumstances, you've got the employee having worked 11 years. So the multiplier is 1.5. So you have 11 times 1.5, and then you times the gross weekly pay at the statutory cap, which is 571. And then you've got the remainder of the 4 years. That's where the employee has worked where they're aged under 41. So the multiplier is 1. So you do 4 times 1 times the statutory cap of 571, and that gives you a total statutory redundancy payment of £11,705.50. So that's a worked example for you. And then the last point on the slide is, do you need to show how a redundancy payment has been calculated? And so the answer is yes, you do. So normally you would put that into the termination letter. So you would set out in the termination letter the payments that the employee is going to receive on termination. And if they're entitled to a statutory redundancy payment, you would set out that payment and you would set out how it's been calculated. And in fact, a failure to provide written statement of how you've calculated is a criminal offence, which does attract a fine. So important that that's dealt with within the termination letter. All right, so next slide, please, Lauren. So the next topic I'm going to talk about is settlement agreements. So what are settlement agreements? Settlement agreements are legally binding agreements between an employer and an employee that are entered into where the employee will settle specific claims in return, usually for financial compensation. So in a redundancy situation, they're often used at the outset of a redundancy, where you've explained that you're proposing to go ahead and make redundancies. You've given your business reason as to why you're making redundancies, and then you can make an offer of a settlement agreement as an alternative to going through that formal process. So that's often used at the outset. It's also often used in voluntary redundancy situations, so where you're inviting employees to apply for voluntary redundancy. And if you're accepting that voluntary redundancy application, you can have that subject to the employee entering into a settlement agreement. And then finally, in a redundant situation, you potentially may have them at the end of the process, where there may be a potential dispute between you and the employee about the fairness of the redundancy situation. So you may want to settle any potential claim regarding their argument about the fairness. So it could be offered at that stage as well. Can all claims be settled by settlement agreements? The short answer is no. And in a redundancy situation, you need to be aware that the claim that can't be settled is a claim for a failure to inform and consult with appropriate representatives on collective redundancies. So that specific claim cannot be settled under a settlement agreement. However, it can be settled via ACAS conciliation. So if you are looking to settle that specific claim, then ACAS is the way to settle that particular claim. But unfair dismissal claims, discrimination claims, and a failure to make a statutory redundancy payment, that can all be covered off under a settlement agreement. So the next point on the slide is, can an employer insist that an employee enter into a settlement agreement? And the answer there is no. You can't insist upon it. So the discussion that you have with an employee about an offer of a settlement agreement must be very much that it's a genuine choice for them to accept it as an alternative to going through the redundancy process. So it must be a choice. They must have free will, and there must be not forced upon them, and there must be no obligation on them to accept it. The risk to you, if you're forcing it upon them and insisting upon them entering into it, is that any conversations that you have about the settlement agreement or the settlement agreement itself will not then be protected. And those conversations in the settlement agreement could then be referred to in future litigation. So to avoid that situation, you need to be careful about the conversations that you're having with employees around the offer of a settlement agreement. So it's just being careful about your conversations there. I think we've skipped on, that's it. So the next question in the slide is, does the employee need to receive legal advice? The answer is yes, they absolutely do. It's a legal requirement that the employee has legal advice on the terms and effects of a settlement agreement. And so even if the employee says to you, I'm really happy with what you're offering, I want to sign now, I want to hand it back to you now, I just want to accept what you're offering me, you need to ensure that they take it away and get independent legal advice on the terms and effects of that agreement. It's usual for the employer to make a contribution towards the legal fees. The standard rate for a junior employee is in the region of about £350 to £500 plus VAT. So that's the contribution that you would make towards the employee's legal advice for taking advice on the terms and effect of that agreement. And then finally, under settlement agreements, the last question there is, can an employer insist on a deadline for the employee to accept a settlement agreement? And the answer is yes, you can insist upon a deadline. So you can ensure that they do sign and return the agreement if they're wishing to accept it by a certain deadline, but you just need to make sure that you are reasonable in the deadline that you are setting. So the ACAS Code of Practice, that sets out a general rule that employees are entitled to be given a minimum of 10 calendar days to consider a settlement agreement. So as long as you've given them that minimum 10 calendar days, then any deadline after that will be deemed to be reasonable. Next slide, please, Lauren. So the next topic I'm going to be talking about is defending employment tribunal claims. So if you have a claim that's brought against you, I've set out here some top tips in defending employment tribunal claims. So if you haven't been successful in settling the claim, either through settlement agreements or via ACAS early conciliation, and then you have a claim that's been submitted and you've received the employment tribunal, the first top tip is to not miss the deadline to respond. And that seems a really obvious point, doesn't it? But you are given quite a strict deadline in which to respond to a claim that's issued. So the tribunal will write to you and they will send you a notice of claim. And within that notice of claim, they will set out the deadline. It's 28 days, but you might not receive that notice of claim on your desk within the organisation for potentially maybe a week if it's being passed around the organisation to find the right desk. So just being mindful that that time does run and you can't miss that deadline. It's a very strict deadline that the tribunal set. So they'll not only send you a notice of claim, they'll also send with that a form that's called an ET3 response form. And you have to complete that form and send it back to the employment tribunal by that deadline. So that's the first top tip. The second top tip then is to respond to all the allegations in the claim. Again, it seems a bit of an obvious point, but many employers don't respond to all allegations that the employee puts within their claim. So do carefully read through the claim form to ensure that every single allegation has been addressed and responded to. To almost treat it like the allegations are skittles in a 10-pin bowling, and you need to make sure you're knocking down every single allegation so that every single one has been responded to. So a really good top tip there. The third top tip is to grasp the net and address any weaknesses in the defence. So in your case, it's always quite tempting, isn't it, just to think, oh, that's a bit of a weakness, let's just dress over that, let's ignore that and hope everybody else ignores it too. The trouble with that is that the employment judge or the claimant's lawyer is going to jump over that straight away. They're going to pick up that point. So it's always best that you address it first, you deal with it in your defence. So for example, if procedurally there's some weaknesses, so maybe that there's some delay in the process, you need to just explain that away. You need to explain why there's been a delay in the process. So the fourth top tip then is to obtain the evidence at an early stage. So what we're finding at the moment is with claims, they're not being heard in the employment tribunal for about 18 months to 2 years. It's a really long time. It used to be the case 10 years ago where the claims were being heard a lot sooner. So 3 to 6 months, claims were over and done with. Whereas now the timescales are a lot longer. So that can put you on the back foot, that can put you at a disadvantage if you don't identify your witnesses early and prepare your witness statements early, because you don't want to be faced with a situation where the witnesses, their memories have faded, and at the employment tribunal, they're saying, I just can't remember, I don't recall. That puts you on the back foot. That doesn't look very credible. You need to have your witnesses fully on top of their evidence. So it's really important that they prepare their statements at an early stage in the process. So that's a top tip that we recommend. We also recommend that you gather all the relevant documentary evidence as well at that early stage. You've all got that all together as well. And then finally, under this fourth top tip is to gather evidence regarding mitigation. So when a claimant has a duty to mitigate their loss, and you want to be able to counter that and to provide evidence to show that they haven't been mitigating their loss. So it's important that you gather evidence of jobs they could have gone for, they should have gone through for, so that you've got the evidence to try and pull down their compensation claim, essentially. So that's a really important thing to do as well at the early stage, and do that throughout the process as well. So you're continuing to gather that evidence. So you've got that ready at the tribunal. And then lastly, the fifth top tip that we recommend is you comply with the employment tribunal directions. Again, it seems a bit of an obvious point, but many parties don't read fully what the employment tribunal is requesting of them. So the employment tribunal will ask you to do certain things by a certain date in readiness for the final hearing. So for example, they'll ask you to submit your evidence that you're going to rely on to the other side by a certain date, and they ask you to submit your witness statements by a certain date. So just make sure you read exactly what the tribunal is asking you to do, and also that you're doing it by the deadline you're being asked to do it by as well. So that covers off our top tips, and then it's just the final slide. And I'm just going to talk to you about a recent case, and that's the case of White against HC1 Oval Limited. And this is just a case that looks at whether or not an employee has any recourse against the employer after taking voluntary redundancy. So it's quite easy, isn't it, to become complacent when an employee has taken voluntary redundancy, to think, oh, it's fine, they've asked for voluntary redundancy, they wanting to leave the organisation, so therefore there's going to be no risk, or really low risk, of any potential claim. being brought against the business. So just have a look at a bit of the background of this case. So it's a care home operator that Mrs. White worked for, and she was employed as a receptionist, and the organisation wanted to make some redundancies in the reception work. So they were looking to reduce the numbers of receptionists. And Mrs. White was provisionally selected for redundancy, and following her provisional selection, she asked for voluntary redundancy, which the care home accepted. So, but after her employment had ended by reason of voluntary redundancy, she brought a claim in the Employment Tribunal for unfair dismissal. And the reason she did that is because she alleged that she had previously raised a grievance which dealt with her having to carry out additional work for which she wasn't paid. And also she said that the receptionist who was working full-time was employed, whereas 2 part-time employees were then dismissed. She thought the whole process was a complete sham. It was all engineered to achieve a certain result, and it wasn't genuine or it wasn't meaningful. So she brought the claim, and the Employment Tribunal struck it out and said, no, you've accepted voluntary redundancy, so your claim has no reasonable prospects of success. So you wouldn't even hear her claim. So as a result, she appealed to the Employment Appeal Tribunal, and the Employment Appeal Tribunal said, well, no, you've got that wrong. That's incorrect interpretation of the law. She should have been entitled to pursue her claim. Just because she has accepted voluntary redundancy, the Employment Tribunal should have looked at the merits of her case and the facts of her case as to what she is alleging. So they sent it back to the Employment Tribunal with a different judge to hear it. It's not been heard yet, so we don't know the outcome, but this is a very useful reminder, this case, that just because an employee has accepted voluntary redundancy, that doesn't mean that there's no risk of them bringing a subsequent unfair dismissal claim. So in that situation, if you want to have that absolute certainty they're not going to bring a claim, and you're offering voluntary redundancy, you want to be thinking about offering a settlement agreement at that time, so that they're entering into an agreement whereby they are giving up that claim to bring an unfair dismissal claim. So that's a bit of a whistle-stop tour from me, but I'll pass back to everyone, and we'll answer any questions that everybody has.
Thank you, Rebecca. I'm aware we've got some questions in the chat box, so we'll try and get to them, and please do stay online if you want us to get to your specific question. Just to say, please do get in touch with us. So after today, if anyone's got any specific questions about managing a redundancy exercise, all our details are on the screen. You know, we're happy to take those sort of 10 or 15-minute inquiry calls without obligating anyone, just to sort of run through any points that you have. Bear in mind, you know, we offer lots of services in terms of advice on redundancy exercises or general employment advice, as well as training. I think everyone will probably see from this morning, the theme really is that communication is key. So if you are doing a redundancy exercise over the next few months, you know, telling people why your business is doing this, you know, who you're going to consult with, what the pools will look like, what people will be scored on, and allowing people to question and to challenge is all really, really key.